judiciary acts as a watchdog and ensures that all the organs of the state work within their respective areas and according to the constitutional provisions following the doctrine of separation of powers. The Constitution provides for the legislative fields. Laws, they can be made in this fashion, on these subjects. So who maintains a vigil on whether laws are being made according to the constitutional scheme? It is the judiciary. Therefore, an independent judiciary independent of the legislature and independent of the executive is necessary, because unless you are independent of the two, you will not be able to maintain a vigil. You are trying to keep an eye on how the other two wings perform, and should they go against the constitutional scheme, you can step in. That is the second reason why an independent judiciary is absolutely essential for the system to survive. Protection of the very notion of a society itself calls for independence of judiciary. An independent judiciary will safeguard the confidence of the people on the avowed object of rule of law and in the very notion of society and civilized living. Compliance with law is ensured due to fear and reverence that citizenry attribute to an independent judiciary. Judiciary that fails to command the respect of the masses would be unable to dispense justice. Any number of laws would remain dead letter if the faith of the people has eroded due to a judiciary that is not independent. Therefore, in a more philosophical sense, it would not be wrong to claim that the legislative and executive departments of the state draw their sanctity from the concept of independence of judiciary, and the existence and continuance of these organs are dependent on it. Judicial independence has become the sine qua non of democracy. Why we pay such tributes to Dr. Ambedkar and the framers of the Constitution? We pay tributes because at a time when we had just stepped out of slavery, you had such brilliant minds that could look into the future, far deep into the future, and see that if this country has to remain together, if this country has to remain united, if it has to progress, what are the aspirations that we must take care of? You rejected the two-nation theory. Pakistan was built on the two-nation theory. They said Hindus and Muslims can't stay together. They're two different nations. Pakistan was created on that basis. But we rejected it. We said, no, we are going to be an inclusive society. We'll have people from all colors, all creeds, all faiths, and they will have equal right. And the tribute that the framers of the Constitution deserve is because of their foresight. That today this country is united, this country is one, this country has given that sense of participation and belonging to all communities, because the basic ethos of the Constitution is that we are a secular, sovereign, democratic republic, where each individual is entitled to profess his own religion, propagate his own religion, without any let or hindrance from any other religion, a religious sect or community, where everyone has an equal opportunity to pursue happiness. In India, we have this concept of equality of opportunity in the matter of public service, or in equal protection under laws, or the equal application of laws. In America, they have a better expression and maybe more interesting expression. They use the word the equality of opportunity in pursuit of happiness. If religion gives you happiness, because you connect to God Almighty, then there has to be liberty to him, equality. He must also, everyone must have the equality of opportunity to pursue any path that gives him happiness, so long as it does not violate the right or the liberty of another individual. So, in pursuit of happiness, you want to compete for a civil service job, you must have an equality. You want to follow a faith because it gives you happiness, you have the fullest opportunity and equality in that also. Whatever words one may use, the equality of opportunity to all kinds of people, regardless of their faith, regardless of their color, their caste, their traditions, equality of opportunity is what gives to each one of our 1.3 billion, strong country the confidence that this country belongs to us. This foresight, or this far-sighted, arrangement that has been evolved in the constitutional scheme is what is admired by jurists and political and social scientists alike. To think of the future of a country, to plan the future of a country, to provide for such meticulous details as to how a state legislature will function, as to how Parliament will, have its members, how the elections will take place, how the election commission will be set up and so on, how public service commission will recruit people, how judiciary will be, functioning and how the appointments will be made, is an admirable job that has been done. But having said that, let us remember that the Constitution is not a static or a wooden document. It's a dynamic document. It's a living document. And therefore, it has been amended over the past 70 years almost 100 times. That also shows the beauty of the document in the sense that you are keeping pace with the developments and you are changing with the changing requirements of the times. Fair and transparent adjudication process is also one of the reasons why it is necessary to have an independent judiciary. Indisputably, the government, be it the center or the state, is the biggest litigant in the country. The idea of a litigant who can, for example, control the composition of the judiciary or the tenure of the judges is antithetical to the notion of justice. Not necessarily real, but the possibility of bias itself would contaminate the adjudicatory process. This is precisely the reason why it is so important to have an independent judiciary. But what is important is that it has been very scrupulously, very methodically provided for in the Constitution. It is not something that we get out of the judgments of the courts. Judgments of the courts do not make law, they only declare the law. They interpret the law. And the pronouncements of the court, when we have spoken about how important independence of judiciary is in the context in which the Constitution places the importance of the judiciary at a high pedestal. Dr. Rajendra Prasad, speaking in the Constituent Assembly about independence of judiciary, said, and I quote, "We have provided in the Constitution for a judiciary which will be independent. It is difficult to suggest anything more to make the Supreme Court and the High Courts independent. It is difficult to suggest anything more to make the Supreme Court and the High Courts independent of the influence of the executive. There is an attempt made in the Constitution to make even the lower judiciary independent of any outside or extraneous influence." There is a very strong commitment in the Constitution itself. And who could speak better than Dr. Rajendra Prasad on this subject, apart from Dr. Ambedkar, who said, "There can be no difference of opinion in the House that our judiciary must be both independent of the executive and must also be competent in itself. And the question is how these two objects could be secured." They were concerned from the very beginning, from the very stage they started discussing about the constitutional framework as to how to achieve independence of judiciary. And according to Rajendra Prasad ji, nothing more was required, because whatever has been said or done in the Constitution makes the judiciary absolutely independent of the executive. Now I will just briefly point out certain provisions which touch upon the judiciary and its independence. Article 50, the state shall take steps to separate the judiciary from the executive. It has to be separate in the public services of the state. There are still, I don't know how many of you know, there are still places in this country where a murder case is tried not by a sessions judge, but by a deputy commissioner. I don't know how many of you know this. In the Northeast, executive and judiciary is not fully separated yet. A deputy commissioner, an IAS officer, is not only the district magistrate, but he is also the sessions judge. He tries the case. Now, you can imagine if the district magistrate was to be the sessions judge, and if let us say, the son-in-law of a minister was to be the accused before him, what would be the state of affairs? How independent can judiciary be? How can you possibly... You see, we have seen there have been situations where the divisional commissioner in a state is hearing a revenue appeal and he receives a call from a political bigwig saying, "Is case ko aise faisla karo." And if the fellow has to continue as divisional commissioner, he has to follow what the minister, the political party or political leader says. So complete separation is the only answer. Separate judiciary from executive, so that no judicial function or no adjudication of rights should be left to the executive. Let judiciary deal with it. That is a constitutional mandate under Article 50. Article 144 says, all authorities, civil and judicial in the territory of India must act in the aid of the Supreme Court. There is a constitutional mandate. No one can say, no, Supreme Court ka order to aaya hai, but I don't care. It's unconstitutional to say so. I remember there was a minister in Kashmir. This is first-hand information I must share with you. Not very familiar with the constitutional setup and the way governments are run and the constitutional ethos or the framework. He was particularly upset because the High Court was issuing some stay orders and that was interfering with the working of his department. So in one of this is long time back, this is, you see, some 30, 40 years ago, nothing to do with the current ministry there. The suggestion, he came up with a proposal, we will issue an SRO, which will tell officers, whenever there is a stay order, don't care for it. I mean, even leave aside common man, common person, you see, who is a layman, less fortunate in terms of education and knowledge and things about how the government runs. A very senior minister in the cabinet could say, didn't understand that, can you at all do this? Can you just simply, he thought an SRO is the last word. A statutory order saying, no stay order shall be obeyed by our officers. If somebody says this transfer is stayed, it will not be obeyed. Now this would be blasphemy if it were to be, you see, implemented. But this is the level of understanding at times among the people, the ruling class also, about the significance of court orders or the impact. Leave aside Article 144, which mandatorily requires obedience to a judicial order. Salaries, and so also, you see, other provisions like impeachment, conduct, etc. Everything is regulated under the Constitution, and appointment of judges is no exception. Of course, the Supreme Court has had many occasions to, you see, interpret this provision. The much maligned collegium system has also been evolved while interpreting this provision. The recent decision by the Constitution bench striking down the constitutional amendment by which the National Judicial Commission for appointment of judges was proposed to be set up also goes into all these aspects, and you see, it discusses how it cannot, the court cannot countenance a situation where the independence of judiciary gets affected by reason of the appointment process being hijacked. The court saw this to be an attempt that would prejudice or that would affect the independence of judiciary. If you have the law minister and if you have two nominees of the government in the panel that is going to appoint judges, the court saw this as an affront to the concept of independence of judiciary. It struck down. There are two views on this. Of course, the government has always held the view that it was a better system. But ultimately, whether a measure, whether an amendment, whether a particular provision is intended to promote independence or it affects adversely independence of judiciary is an issue on which somebody has to have a last word. And under the scheme of things in this country, what is the Constitution and what does the Constitution provide for is something which only the Supreme Court can authoritatively pronounce upon. So what is the Constitution or what is the constitutional requirement is something which must be finally left to the opinion of the apex court. And if the apex court says it affects independence of judiciary, there is no way one can say, no, that is not the position. So these articles have been, you see, discussed and interpreted at great length by the Supreme Court in several decisions to which I need not refer because I am conscious of the fact that this is not a purely academic and legalistic kind of a issue on which we are looking at. We are looking at this from the perspective of a common man, the concept from the perspective of a common man. I am not addressing lawyers. There may be some distinguished lawyers also sitting here. Mr. Tulsi is here. Some other very distinguished people also who understand the system. But generally I feel we need not get into the details of how, you see, the juristic basis was evolved for this judgment and how far there can be two opinions. The international framework, may I tell you, it is not as though we are trekking on a solitary or a virgin kind of a trek where there has been no traveler before. No, we are in tune, if I may say so, with the international climate or the international ethos on independence of judiciary. For instance, Article 14 of the International Covenant on Civil and Political Rights, ICCPR, states that all persons should be equal before the courts and tribunals, and further, that in the determination of any criminal charge against him or of his rights and obligations in a suit of law, everyone shall be entitled to a fair and public hearing by a competent, independent and impartial tribunal established by law. It's an international covenant. It's an international requirement. It is not as though we have, you see, discovered the wheel for the first time. No. All civilized systems in the world have accepted that if there is a matter to be adjudicated upon, whether it is between two citizens or whether it is between a citizen and the state, what is emphasized is that it must be done by a competent, independent and impartial tribunal. No, you call it a tribunal or a court, the idea is that it must be independent. This is one. According to Article 10 of the Universal Declaration of Human Rights, everyone is entitled in full equality to a fair and public hearing by an independent and impartial tribunal. Again, this is Universal Declaration of Human Rights. So what we have incorporated in the Constitution is actually a universal human right acknowledged in all civilized systems. Now the conclusion part. What are the challenges to the independence of judiciary? Now there can be no doubt that the challenges can be both external and internal. And it is not as though there have never been situations or there have never been challenges which could, if unaddressed or unaborted, would not have affected judiciary. There have been situations. For instance, A powerful and assertive parliament tries to assert for a greater say in the matter of judicial appointments. As I said about the attempt uh, to, to take away from the judiciary the power to appoint judges was an attempt which was seen by the judiciary as an attempt to affect the independence of judiciary. Constitutional amendments seeking to set up a National Judicial Appointments Commission was one such attempt. It was seen as an attempt that would affect the independence of judiciary. Financial interference is another. Not in this country. In this country, so far, there has never been, you see, there has never been a situation where judges have said, no, you are giving a step-brotherly treatment just to kind of make us ineffective or less effective. That has never been. But this is an apprehension, not unrecognized, but recognized in certain countries. For instance, in the Australian report of the Remuneration Tribunal of Commonwealth of Australia, 1997, it said, and I quote, "Those who control the purse strings will always have some capacity to influence the actions of those who are dependent upon the contents of the purse. There can be no doubt that executive government control over judicial salary fixation is always at least an incipient threat to judicial independence." Not a direct or a covert thing, but it is always an incipient threat to independence of judiciary. This is seen as one of the possible areas where independence of judiciary can be affected. Supersession of judges has been, of course, always seen as something which has affected the independence of judiciary. And if I may only point out a few passages which have been written on supersession of judges. For instance, Justice Subba Rao, former Chief Justice, in an article published in the Statesman on May 14, 1973, under the heading, "The Supersession of Judges, the Price of Executive Interference," says, and I quote, "The supersession of 3 senior judges in the matter of the appointment of Chief Justice of the Supreme Court on the day after the Supreme Court delivered its judgment in the fundamental rights case ignited a controversy throughout the country. Almost all leading advocates and most of the bar associations questioned its propriety. There is a conflict among the political parties. The Congress and the CPI supported the action and all the other parties opposed it. In Parliament, the discussion proceeded on party lines. As the action affects the independence of the judiciary, it is necessary that the intelligence should carry out a national dialogue throughout the country." Independence of judiciary was seen as affected by the supersession. Palkiwala, in his book, A Judiciary Made to Measure, says this: "A joint statement by MC Setalwad, MC Chagla, former Chief Justice of Bombay High Court, K.T. Desai, former Chief Justice of Gujarat High Court, V.M. Tarkunde, former Judge of the Bombay High Court, and N.A. Palkiwala, was also issued under the caption, "The Saddest Day in the History of Our Free Institutions." It said, "The Government of India's decision to supersede 3 senior most and highly respected judges of the Supreme Court is not only unprecedented in the nearly quarter century of the court's existence, but is a manifest attempt to undermine the court's independence. This improper action will inflict great and lasting damage on the judiciary. It is the saddest day in the history of our free institutions." And Palkiwala in particular said, while addressing the general body of the advocates, in this, also protested the supersession and said, "Clearly, as a matter of principle, we think it our duty to express publicly our protest at this unprecedented step, which will undermine judicial independence and the dignity not only of the Supreme Court, but also of the high courts and other courts in India, where now the same pernicious practice may be followed by the state government." And a very large number of other jurists found and declared this to be a great injury to the independence of judiciary. Coming to internal challenges, the internal challenges to the independence of judiciary are generally perceived to have arisen from lack of accountability or erosion of credibility in the public mind, which late Justice J.S. Verma, former Chief Justice of India, has made a reference in his lecture where he says, and I quote, "The existence of power must be accompanied by accountability. Erosion of credibility in the public mind resulting from any internal danger is the greatest latent threat to the independence of the judiciary. Eternal vigilance to guard against any latent internal danger is necessary, lest we suffer from self-inflicted mortal wounds. The absence of any codified rules or norms to regulate judicial behavior at the higher levels has been on account of the view that those entrusted with the task of regulating the conduct and behavior of others do not need to be told of the requirements from them. However, if we fail in living up to that expectation, it should not be surprising if in the near future there is move by an outside agency to step in and provide a solution to the felt need. The need of the hour, therefore, is to realize this clear and present danger as an imminent threat to the independence of the judiciary from within. In my view, there is no time to lose and we must act promptly. Observance by us of the norms and guidelines indicated for the members of the judiciary by the ancient texts and the judicial verdicts is a sure way to prevent any threat from the lurking latent dangers from within. It would also satisfy the legitimate expectation of the people for accountability, which must accompany the investment of any public power. Very recently, Mr. Nariman, one of our very widely respected and eminent jurists, wrote an article in which he also used the expression, he said, "The citadel crumbles from within." So I think out of all the dangers that independence of judiciary may have, I think the most pernicious and the most dangerous or lethal that one needs to guard against is the danger from within. The court needs to remain united in its resolve to uphold the Constitution and to maintain the credibility with which it has been blessed and the confidence which the people of this country have in this great institution. Thank you very much and God bless you.